Ready? Start. Mr. Nayak submits that a perusal of the testimony of all the witnesses would reveal that there was no premeditation. Stop. The incident occurred in a sudden fight in the heat of passion upon a sudden quarrel. Stop. She submits that the weapon used in the crime was a pocket knife. Stop. She further submits that a single injury has been caused with the use of the said knife. Stop. She therefore submits that the present case would squarely fall under Part 2 of Section 304 IPC in as much as the appellant had no intention to cause death of deceased. Stop. She further submits that the prosecution has failed to explain the injuries sustained by the deceased, and as such an adverse inference needs to be drawn on account of the same. Stop. Learned senior counsel, on the contrary, would submit that both the trial court as well as the high court, upon correct appreciation of evidence, have found the appellant guilty for the offence punishable under Section 302 of the IPC. Stop. It is submitted that on account of previous enmity arising out of the appellant molesting the wife of the deceased's elder brother and the deceased's questioning the appellant about the same, the appellant had intentionally committed the crime. Stop. She therefore submits that no interference is warranted in the present appeal. Stop. Taking into consideration the nature of injuries sustained by both the accused persons as well as the deceased, the possibility of the incident taking place in a sudden fight in the heat of passion upon a sudden quarrel cannot be ruled out. Stop. It is further to be seen that there is no evidence to show that the appellant has taken undue advantage or acted in a cruel or unusual manner. Stop. It is further to be seen that the weapon used is a pocket knife. Stop. The injury caused by the said knife is a single injury. Stop. We therefore find that in the totality of the circumstances, and particularly on account of the injuries sustained by the accused persons, the appellant is entitled to the benefit of exception 4 to Section 300 IPC. Stop. We are therefore inclined to partly allow the appeal. Stop. The conviction of the appellant under Section 302 IPC is altered to the one under Part 1 of Section 304 IPC. Stop. The appellant is sentenced to suffer rigorous imprisonment for 8 years for the said offence. Stop. The appeal is partly allowed in the above terms. Stop. This appeal challenges the judgment and order dated 8th January 2019 passed by the Division Bench of the Allahabad High Court in criminal appeal, wherein the Division Bench dismissed the criminal appeal preferred by the appellant and upheld the order of conviction under section 302 of the Indian Penal Code. Stop.